My name is Ben Cook. I'm a detective with the Pinal County Sheriff's Office. I have 24 years with the Sheriff's Office. I've spent the last couple years as a detective. I work property crimes. I've worked every region of the county. I've done search and rescue, school resource officer, training. I've been just about everywhere. I was brought in today to teach the search and seizure portion of your class. So the first slide that you're going to see is talking about the performance objectives. The class is kind of small and engaging, and we go over the things that are important, but there's a lot of things that you'll want to go and read on your own. So when you see these performance objectives that are going to be on your screen, we may not dive deep into all of them. We try to cover them all. There is a ton of case law that goes with this class. This is a huge book. All this will be available online for you to review. So let's jump right into it. We're talking mainly on the Fourth Amendment of the Constitution. So I look to my side because I'm looking at a screen that you guys will see on your screen. The Fourth Amendment is the right of the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizure. Shall not be violated, no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Why is this important to you? That's the question that comes up, is why are we teaching this specific class to you guys? Well, when and if you're called up to do whatever role the sheriff has asked from you guys as the citizens posse, you now fall under the umbrella of the sheriff's office, which means you're subject to the same rules that we are, and you are, in a sense, in our employ, so you have to know what it is that we can and can't do. And when we look at the Fourth Amendment, and you look at that screen, there's two words that I want to concentrate on. The word unreasonable and the word probable. Our founding fathers for this Constitution were awesome in how they worded these things. This is a black and white amendment with gray areas where we grow and where our country grows. When they wrote the Constitution, there were no cell phones, there were no planes, no drones, the computers, all the technology that we have today. Yet the Fourth Amendment can still apply today, over 200 years later, because of the two gray words that are inside of that amendment. So we're going to spend a lot of time looking at unreasonable and at probable as we go through this lesson. So a search, what's a search? The Fourth Amendment says that we can't have an unreasonable search. Well, before we can go too far, we need to look into the black and white definition of what search is. A search is an intrusion by the state into an area where the person has reasonable expectation of privacy. Reasonable expectation of privacy. We go back to that word that's in the Constitution, reasonable. It's again, a gray word that doesn't have an exact definition. We talk about seizure, a seizure relating to a person at its lowest level. So we're talking about seizure, stopping a person, and there's different levels of seizures. At its lowest level is a restraint where the detainee is not free to leave. Perhaps a traffic stop. Maybe you're stopped on the corner of the road as you're walking and you have been detained by law enforcement. They show up in a uniform. You have the belief, I don't have to express it, but you have the belief as a citizen that you don't have the right to leave, that you can't walk away from the situation in which you're in. This seizure must be justified by reasonable suspicion. More gray words, more words that require definition, that are tough to define, reasonable. A seizure at its highest constitutional level is an arrest. This is where we have now put handcuffs on you. We have restrained your movement. We have violated the very base of our country, which is being free, and you're no longer free. You have now been detained and your freedoms have been taken away. That is a seizure. We have seized you, the body, and it must be again justified by probable cause. I'll tell a story. I remember the first time I did a traffic stop. This is 24 years ago. It was near Central Arizona College, just between Coolidge and Casa Grande. The traffic stop, the sense of, it was an overwhelming sense of power that you really don't understand until you've done that traffic stop. Makes you, the adrenaline pump, your heartbeat. I can remember my first traffic stop. I'll remember it forever. It just gives you this sense of responsibility that's overwhelming. That's the impact of the Constitution and seizure. So let's talk about a search warrant, and I'll have a blank copy of a search warrant that hopefully we have on your screen. So a search warrant is an order. This isn't a request. This isn't me asking you if I can come into your house. This is an order. It's a written order issued in the name of the state of Arizona, signed by a magistrate, directing. We're not given an option. We can't go to the door and change our mind. We are ordered to search a personal property, person, or item. That means the consent of the person, the owner of the property, the owner of the vehicle is not required. We are not going to ask. We will be as polite as we can when we come and serve the search warrant, but basically we're going to tell you in a conversation, in the end, we're going to tell you have to get out of the way, or we're going to put you in handcuffs and we're going to place you in the back of the car for obstructing. We have an order from a judge, a magistrate, the JP, whoever it is that signed that order. We have an order that says you must do this. We are not given a choice. And you'll see the search warrant that's on your screen. It'll come in 3 parts. There's what we call the search warrant, and that's the order. We have an affidavit, which includes a probable cause statement. We have to write out to the judge the story of what happened and supply him with what he believes to be probable cause that allows the authorization of the warrant and the command that we're given by that judge to perform the search. Once we have that search warrants, there's different ways that we're allowed to serve the warrant. So in normal circumstances, I'm going to get that search warrant signed by the judge. It's going to tell me between the hours of 6:30 in the morning and 10 o'clock at night. I'm going to go up to your door and I'm going to knock on it. I'm going to wait for you to respond. I'm going to serve you with the search warrant, and I'm going to search your person, property, whatever it is that we're required to search. It could be as much as taking a DNA sample. But that's what we call a knock and announce. We're going to knock on the door and announce what we're doing. We have the means to request a no-knock search warrant, which means we're going to go and approach your house, and the knock is going to be your door being knocked down. And there are circumstances where the level of danger to our officers is so high that we bring in, again, a probable cause statement to the judge and say, look, in the interest of safety for our deputies or our officers, our SWAT team members, our detectives, whoever it is, we don't want to knock on this door because we're afraid that something could happen. In order to avoid that, we are going to surprise them. We are not going to knock. We're going to bust the door in and come in and serve our search warrant. In addition to that, we can ask for a nighttime search warrant, one that's done after hours. So after the hours of 10 to 6:30 in the morning. But again, we have to establish probable cause for any of these. In addition to the probable cause for the search warrant, we have to have probable cause for the method that the search warrant is being served. So I keep saying the words reasonable suspicion, probable cause. What are these? What are these words? What is the definition? Well, the courts have determined that they are not really definable. We can't come up with a concrete black and white definition. We can't put an exact percentage on the amount of evidence because it's case by case by case. Each case has its own set of circumstances which reflect its own reasonable suspicion, its own probable cause. So what we're going to put on your screen says reasonable suspicion is more than a hunch, but less than probable cause. Again, we're defining something with something we don't know the definition of. but they're articulable reasons to suspect that criminal activity is ongoing and that the person stopped is involved in that criminal activity. So I'm driving down the road, I'm in my marked unit, there's a bank robbery, and they say it was a red Chevy truck with 2 occupants, and they give a description. I'm driving down the road and I see a red Chevy truck with 2 occupants and everything is there. I have reasonable suspicion to stop that vehicle. Once I approach it, my job is to try to establish probable cause or to eliminate my reasonable suspicion. So I'm looking for which way I'm gonna go in this. I'm gonna start asking questions, and sometimes the questions are gonna take me to the end where I need to let you go. Sometimes they're gonna take me to the place where I need to hold just a little bit longer and keep asking questions until perhaps I get probable cause. Probable cause is the situation occurring when the police have reason to believe that a person should be arrested. In making their arrest, police are allowed to legally search for and seize incriminating evidence. So once I've taken you into custody and I've completed that seizure of your person, I now can search your person for my safety and the safety of all those you're going to encounter. We perform a search. It will pat you down. We're going to empty your pockets. We just can't let you continue with whatever you want. I talk about different cases when I talk about search warrants. And so with that, we're going to go into exceptions for a search warrant. And the first and most important one to us when you talk about an exception to a search warrant is consent. If I walk up to you and I say, can I search your house? And you say, yes, come on in. I don't have to have a search warrant. I'm coming into your house on your consent. You are allowing me to trample or step on or overlook your Fourth Amendment right. You've given me the authority to forego the Fourth Amendment, forego a search warrant, and come into your property, whether it be your house, your car, or otherwise. And I talk about a case where I had a burglary. So an elderly lady's at home. She lives by herself. She leaves to go, I think she was going to the post office that morning. She leaves, she's only gone about 30 minutes. When she gets back, she walks in, and her front room, somebody has busted the window out, gone through her house, and things are broken. There's glass broken, the cabinets are gone through. The person went through the kitchen cabinets and the bathroom cabinets. And you can see that they've looked at the medications. So whoever it is probably looking for a prescription drug that they can use later on. When they've done this, they cut themselves on the glass. There's a nice drop of blood on a fresh piece of glass that I can tell happened after the window was broken. The broken glass is on the ground. The drop of blood is on top of the broken glass, meaning it didn't happen while the glass was still in place. We collect that sample of blood in the hopes that we can find a match. In talking to the owner of the house, she says that the neighbor was outside as she left, and she says he's a real, in her words, a real suspicious character. So that's an avenue that we can go. We're going to try to follow that up. I go talk next door. Nobody's home. A little while later, I'll try to make the story shorter. The person that is the suspect comes home, and I'm talking to him, and I can see he's got cuts on his hands, which are kind of consistent with the broken glass, but it's explainable. He could have cut him any way he wanted. But we're talking, and in my investigation, I knew that there was blood on the back wall that went from the woman's house to this kid's house. So I'm still, my suspicions are higher, but right now all I have is suspicion. It's not enough for a warrant. When I'm talking to the young man, I said, I have a sergeant who really likes me to follow up and take everything to the very end that I can. They want everything done. I just need to do a couple things just because I want to eliminate you as my suspect. I don't want there to be any questions. I said, do you mind if I take this swab and rub the inside of your cheek? And he looks at me and he goes, yeah. He goes, sure, go ahead. And he opens his mouth, and I take the swab. We have 2 of them. We have to rub it on the inside of your cheek. It collects the skin cells from the inside, and we collect the DNA sample. I sent that DNA sample off to the lab. I sent it with the drop of blood that we collected from the broken window. Evidence said whoever dropped that blood there also broke the window and more than likely entered that house. When I sent them to the lab, they gave me the results. When the results came back, they said there was a 1 in 240 decillion chance that it was not the guy that I was talking to. And I'm going to try to write this out just so you guys can get a glimpse. 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 29, 30, 31, 32, 33. That's a decillion. 240 decillion chance that it was not the guy that I was talking to. So basically what they were saying is, I have the guy. This is your guy. So with that, we were able to make an arrest. That guy, that kid, he didn't take anything from the house, though he did cause a lot of damage. He is sitting in prison for burglary, criminal damage. I think they may have even stuck in elderly abuse. But the thing is when I'm swabbing his cheek, we're talking still. He's talking with this in his mouth, and he goes, "Don't you have to have a search warrant when you're to do this?" And I told him, I said, "No, not as long as you're letting me." And I just kept rubbing his cheek, go a little faster so I could make sure and get my sample. But I told him, if you're letting me do it, I don't have to have the search warrant. So other exceptions, I spent a lot of time on consent because that's a big one for us. We're going to ask you, even if I come to your house with a search warrant, I'm going to ask you, I'm going to say, look, we'd like to come into your house and do a search warrant. We have the warrant. We want to search your house. We're going to talk about it if it's a knock warrant. I'm going to try to be as kind as I can, but at the same time, we have to be assertive. We can have exigent or emergency circumstances that allow us to enter your property. Maybe there's smoke rising from your roof. Well, if there's smoke rising, I don't know if there's people there. I don't have to go to a judge and ask them to sign a warrant to go into your house to investigate for a fire. Now, I can't go into your house and start looking through your drawers and seeing what I can find. I mean, that's not the reason I'm there. I'm there for that emergency. So that's my job, is to go there, take care of the emergency, and not infringe on your rights as much as I can. Incident to arrest, we talked about. If we take you into custody, we have the right to search your pockets, empty them out, take the property from you so that you go into our jail or whatever facility, which is a sterile environment. We want you to be sterile of any obstructions as well, anything in your pockets. We have what's called plain view, and I believe we're going to go over that here in just a little bit. So plain view, if I walk up to your car and I look in your window and there's a big bundle of marijuana sitting there, that's plain view. I don't have to have a search warrant and go get a judge and tell you, you go on your way, I'm going to get a search warrant and come back and search your car. It's in plain view. That's probable cause. I can make my arrest. I can enter the car and take that evidence. Open fields. So if I'm walking, farm fields are the biggest thing. If we're walking, there's a big farm field and I can see a big marijuana grow, that's an open field. I had the right to look, I can see it, I can act on it. Mobile vehicles, if at all possible and we can write a search warrant on there, we're going to do it. If not, we're going to hold and seize that vehicle and possibly search it. That's one that's going to take some time. And if you're encountered in something like that, you're going to want to talk to one of the detectives or deputies. Inventory. So we've done, I'll give you an example. We did a traffic stop. We've stopped you. We made an arrest. Your car is sitting on the side of the road. We can't leave it there. We're not allowed. It's unsecured. We're responsible for that vehicle. So the way we answer that is we tow it. But at the same time we're responsible for the vehicle, we're also responsible for the contents of the vehicle. So to affect that tow, we have to inventory your vehicle, which means we're going to open up the doors, open the trunk, take an inventory of what's in there so that nothing gets taken when it's at the tow yard. When it gets there, all the items are going to be written down on it. If something comes up missing, we're going to say, yes, it was there when we towed it. Now we have another investigation into the theft. The last category on your post there is abandoned property. The best example of this is when you wheel your garbage can out to the curb. You wheel your garbage can out there and leave it there for that garbage truck to come and take. It's been abandoned. It's abandoned. We now, once it's out there, have the right to search it. If your garbage can is in your garage, we don't have the right to go and search that. It hasn't been abandoned yet. So we're talking about plain view, and this one is so odd. There's so much that we have to worry about when it comes to plain view. What is plain view? Well, if I'm walking like the description I give you, and I walk and I look into your car and I can see the bale of marijuana there, that's plain view. But if I have to walk up to your car and open the door to see that bale of marijuana, it's not plain view. It wasn't, because I had to take an action in order to see it. You got some pictures on your screen that are going to show a wall. So there's a wall here. In one, the officer can see over the wall. He has the right to be where he is. He's on the outside of the wall, and he walks up and he looks over it, and boom, there's his evidence. That's plain view. But in the second picture next to it, he had to get a ladder to get to the top of the wall and look over. That is not plain view. And I'm going to give you a case story. This is out of Tucson. I believe it was called Olm versus Arizona, OLM versus Arizona. So you guys will be able to look that up in your online when you see it. So it'll be Olm versus Arizona. In Olm versus Arizona, down in Tucson, the detectives called a patrol officer, I say deputy a lot, called a patrol officer and asked him to go by this house. This house, the owners were suspected of being a chop shop, being involved in stolen vehicles and stolen vehicle parts. They wanted him to go by this house and get the VIN off of this car. So here's the house, here's the sidewalk, here's the driveway, this is a little porch. It's kind of a crude drawing. I draw the arrow to show that the car's facing that way. This is just the yard. So some people will park their car in their yard. We see it all the time. There's no car in the driveway. So the officer comes up, here's the road. He drives up in his car, he parks in the front, and he walks up the sidewalk, comes to the front door, knocks on the front door, nobody answers. Well, the car's sitting right there. It's probably 10 feet away from him. He wants to get the VIN. So he walks from here over to the car and looks in the window, writes down the VIN number for that vehicle. They go back, and when he's looking at it, he finds that the VIN plate has been altered. It's bent, it's broken up, it's not the way it's supposed to be. Well, you're not allowed to alter or remove or damage the VIN plate on your car. So he goes back and he calls the detectives and says, detectives, this is what I got. They say, cool. And they come down and they write a search warrant. They provide all the evidence to show this huge chop shop and a huge ring on these stolen vehicles and all this stuff. So this event goes to court. In court, they are arguing this one action that this officer took. And they're saying, the argument is was that plain view? Was it plain view for him to come here and look in there? He didn't use any means. He didn't use binoculars. He didn't have to get on a ladder. He didn't have to do anything to view the VIN plate. But what he did have to do was leave the expectation area. So you have an expectation of privacy on your land, and you have avenues that you've designated as areas that people may walk to approach your house. Say you have a visitor that wants to come, it's expected that they're going to take the sidewalk and approach your door. Once that officer left this expectation area, he now infringed on this person's rights to their privacy. So by leaving that sidewalk, now let's change this a little bit. Had they not had a sidewalk, we see that all the time where houses don't have sidewalks. They don't have an avenue to approach the front door, and that officer did this, it would probably have been reasonable. In the case that we're doing, Ohm versus Arizona, it was determined not to be reasonable. The whole case, everything that was obtained after or as a result of that, obtaining that VIN, was thrown out. Because that's called the fruit of the poisonous tree. The seed that planted that tree was the obtaining of that VIN number. Everything that came from that seed is thrown out, called fruit of the poisonous tree. So if the officer is where he or she has the right to be, whatever is observed in the open, where it can be seen by anyone who cares to look, is in plain view. And it is not a search to observe it. So again, let's go back to what the founding fathers intended versus today. So you have a piece of property, you fenced it with a wall. You have this wall all the way around. Maybe it's an 8-foot wall. You have this huge trench that's dug around there so nobody can even approach your wall. You've taken steps to make sure that nobody can come into your property or observe it by plain view. But a helicopter flies over. Boom. Helicopter flies over, and while they're flying over, the police officer looks out the window and looks down, and lo and behold, there's your criminal activity, whatever it may be. We have to ask, is that plain view? So now again, we have to look back at what that Constitution says about what is reasonable, what is probable cause, and what is reasonable. The big thing here is it reasonable for that helicopter to fly over the property? Well, that happens every day. Every day. So what is your expectation of privacy in the area that expands forever above your house? I mean, at what point do you no longer have an expectation of privacy? Now let's take that same comparison and say we don't even have to have a helicopter. What about a drone? We have this drone that comes up and flies over the property, and it has a camera, and it looks down, and we can see, again, the criminal activity that's in your yard. Two different scenarios, helicopter, drone. The helicopter is legal. The helicopter was legal. He's allowed to fly, probably 400 feet is the expectation of privacy. He's at least 400 feet or higher, looks down with his own eyes into the yard and sees the activity. Legal. Can be done. The drone comes up, flies at the same altitude. The camera looks down. I have my viewing platform, whatever it is, and I'm looking into that backyard. Illegal. It is not plain. I'm using a camera to view the criminal activity. I'm not seeing it with plain view. That's what the courts have determined when it comes to plain view in that sense and what is reasonable in that sense. Now, the founding fathers never, I would say probably never fathomed drones and these things that didn't have people in them, if they may have thought of flying instruments. So here again, our Constitution that's written over 200 years ago is addressing things that are happening now. And it's effective. What it is doing is it's clouding us up, the government, with case law. We have to know our case law. We have to go back and review all of these. As new case law comes out that starts to mold reasonable and mold suspicion and mold probable cause for us, we have to pay attention to see where it's going so that we stay where we're supposed to be. This is you, the people, deciding what me, the government, can and cannot do. So we're talking about Terry stop back in the 60s, probably late 60s. We have a police officer that's in his patrol car. He's parked on the side of the road. He's probably doing paperwork, whatever it is. He's got his lights off. He's watching this plaza, a row of buildings, businesses. As he's watching it, he sees two guys standing kind of in a dark alley. The area is not lit well. It's a high crime area. They've had a high influx of burglaries in this area over the last couple weeks. He sees this adult male walk down the sidewalk, come in front of a business, look into the business for a couple minutes, and then walk back and meet with his partner. The two talk for a few minutes. Now the second guy walks down there and he looks into the business for a couple minutes. And he walks back over to where the other guy was. They're met by a third guy. The third guy walks over, gets in front of the business and looks in. Same business, all three of them are looking in, then all three of them come back together and converse. It's not lit, the business is not open, this is the middle of the night. It's suspicious in the officer's mind. At this time, it hadn't been determined what was allowed and not allowed, but he did approach these three people. The officer gets out, talks to them, holds them, and he pats them down. So this is a burglary, is a felony. It's an activity that is most of the time accompanied by weapons of some sort, whether it be a tire iron, a screwdriver, a gun, whatever it is. There's usually some type of tool that is used at the time that burglary is being committed. So he wants to pat them down and find out if they have anything. It hasn't been discussed yet at this time in the courts as to what level of intrusion that we're allowed. He's not diving into the pockets. He's feeling from the outside. And what I would tell you to do is, take husband, wife, friend, child, and put something in their pocket and just take your hand and you're going to pat. And you're going to go through. A lot of times we do a squeeze. So we'll squeeze wherever it is that we're feeling just to see what's there. We're not intruding in until we find something that we believe resembles what could be a weapon. Now that could be, we feel a screwdriver, we feel a gun, we feel a knife, we feel something that it can be used as some type of weapon. At the same time, after doing this for 24 years, I can feel a bag. And in my experience, that bag feels like what it is that people carry their methamphetamine or their heroin or whatever drug, or maybe it's a pipe that I feel. And the contour of it feels like a marijuana smoking pipe or a methamphetamine smoking pipe. And I can feel those. And because I had the right to pat them for a weapon, at the same time, if what I feel is a pipe that I believe to be illegal, I don't have to ignore it. I can take that out of their pocket and use that as evidence against them. It's just a pat down. It's called Terry versus Ohio. We must have suspicion to start this. Again, suspicion is a word that has to be justified on a case-by-case basis. In this case, the Supreme Court said, yes, this was suspicious circumstances. When you put everything together, it was suspicious what those three gentlemen were doing. So the officer was within his right. He was within his right for officer safety and otherwise to pat this person down, and then he did find evidence of criminal activity. So that's Terry versus Ohio. I challenge you to just take the opportunity to pat someone down sometime. Spouse, kids, whoever it is, make sure you have their consent, but pat them down and see what things feel like inside their pockets and if you can identify what it is. That's all we're doing. We're going to pat them down. In many cases, I'm going to ask them when I'm doing it, hey, do you mind if I pat you down real quick? I just want to make sure you don't have any weapons on you. And I'm going to ask, we go back to that consent. So if you say yes in that instance, I don't have to worry about Fourth Amendment. I don't have to worry about any of this. When I approach you, the circumstances are suspicious in nature, maybe. Maybe I'm hinging on what's suspicious. But I'll ask you, can I pat you down? If you tell me yes, you have foregone your Fourth Amendment right. I can now pat you down. I'm going to do whatever I can get away with, whatever you'll let me do, whatever you give me consent to do. But once I felt something, I've now moved from whatever it was, suspicion, to probable cause. So once I've felt that pipe, that gun, that knife, I've now moved up to a probable cause that there's something going on. Maybe not the level of probable cause, but the probable cause is that there is a weapon involved. Now I can remove that weapon and continue my investigation. So again, we talked about the Terry versus Ohio. We'll skip through that. There's a lot of information. Terry versus Ohio is very important when it comes to what we can and can't do when we're approaching a person. And just remember, the big thing here is we have the right to do it, but a lot of times we're going to ask for your consent. You have the right to say no. If we can do it without your consent, we're going to. If we have the right to pat you down, we are going to pat you down. If you start to resist, now we've upped our level and we may be going towards probable cause where an arrest is warranted. If we can say there was enough suspicion there for me to pat them down and they refused, we got into a struggle of some kind, you start to fringe on us establishing probable cause for a reason for arrest. But you can say no. You can say no. So on traffic stops, this is one of the big ones where we talk about consent. You'll see it all the time. Officers will stop you. They stopped you for, say, you had a tail light out. And they come up and they're talking. They're asking where you're coming from, where you're going to. They're investigating. They had the reasonable suspicion to make a stop. We now have a certain amount of time to conduct our investigation. We can look further, but it has to be reasonable. We can't detain you for an hour because you had a tail light out. We can look for the VIN plate on your car. We can ask you for a driver's license. We can run your name for warrants in our system. We can check your registration to make sure you have valid registration. We can check to make sure that you have insurance. You're required to have it. We can ask for it at that time. Then we come back, we're doing our research onto warrants, registration, driver's license, making sure everything's valid. We address the issue of whatever the traffic stop was for. Now we can, once we tell you we're done with the stop, the officer may want to continue to talk to you. He may say, hey, I'm giving you a warning for your tail light out. You don't have to stay here anymore. He may just say, I'm giving you this warning, and start to talk to you some more. If you don't want to talk, you don't have to. You can ask him if we're done, and you can leave. If you consent to engaging in further conversation, again, now we're dealing with consent, and you have foregone your Fourth Amendment protections. So, exigent circumstances on an emergency. I'll give you an example. Say we're in a pursuit. So we're chasing a person there was a vehicle infraction, say it was speeding, say there was some kind of action that happened. We initiated a traffic stop and that person didn't stop. We activated the lights and sirens as we're required by state statute. We are going to conduct a seizure on your person and your vehicle, only you refused. Now we'll go back and identify the reason for the seizure in court, but if it was deemed to be a legitimate seizure and you run, that's called a pursuit. That's failure to yield for law enforcement. We have the right to pursue. Now we pursue you and you drive all the way home, get out of your car and you run in your house. Well, it's not sanctuary. We are pursuing you, and when you stop, we stop, you get out and run, we get out and run. We're going to run right behind you, right into your house, and we're still going to affect our arrest. Only now, instead of the citation that you were going to get, you're now getting some handcuffs and you're going to jail for a felony offense. So that's called hot pursuit. We've pursued you into the place where you normally have protections based on the Fourth Amendment, but we're in pursuit of you. You can't just run and expect that you've crossed some magic line and we're not allowed to go after you. So we have an exigent circumstances based on bomb searches and investigations. We won't go too deep into that. That's pretty obvious. If we have some kind of bomb threat or knowledge of something like that, some kind of terrorist activity, there are exceptions to getting a search warrant. However, most of the time, if it's reasonable to do so, we go after the search warrant. Again, it may not be reasonable if there's a bomb threat. We have protective sweeps. Protective sweeps is we have done something, we have found this house to be involved in that, We want to write a search warrant, but we can't let the activity that's inside the house continue. Say we went in, and as we come in, there's a dead guy laying on the ground. I mean, horrible, we don't like it, but something happened to that guy. We need to do what's called a protective sweep of the residence to make sure that our perpetrator is not still in the house. We're going to walk through the house, we're going to open doors, closets, things like that to make sure that there's no one in there. One, no one in there that's going to hurt us. Two, no one in there that's going to destroy evidence. We're going to do that sweep, secure any persons, and then we back out and do our search warrant. So the protective sweep, we're not going to, again, be looking in places that a person cannot be hiding. So we're not looking in your jewelry boxes for a person. We're looking in places that are reasonable to find something that can destroy our evidence. And that's what the protective sweep. So that's an exigent circumstance, but we're doing that in anticipation of getting a warrant to search that residence. But we have to secure it first. So we kind of went through this kind of quickly. Normally we would engage and ask questions. If you have questions, I'm sure there's going to be a way for you to contact us. Whoever the representative, I believe Sergeant Harrison is your contact through the Citizens Posse. Get a hold of him, ask us questions, refer back to the case law that's attached on the website. And that's all I have for you guys today.